Sometimes a business can do everything right. Hire an attorney, set their business up correctly, ensure that they've got solid contracts and agreements with their customers, their clients, their vendors, their employees. And they go through a procedure and we're still finding ourselves in a dispute with somebody from the outside. How do we like to approach these type of situations from a Koegle Law Group perspective when we're advising clients when a dispute appears to be unavoidable?
Sometimes there are situations where you do your best to try to resolve the situation informally, you negotiate with the other side. What you really have to do is communicate with your opposing party and say, what is it that you think was inappropriate? How can we resolve this? Sometimes there are going to be situations where no matter how hard you try to fix the situation, you just can't. And unfortunately, in those situations, you're left with only a few options. And none of them are particularly great options, but they are what they are. You can try to go to a mediation before filing a lawsuit.
What is mediation?
Mediation is basically where the parties, you and your contractor or vendor who you have the dispute with, you agree, we're going to pick this person to mediate the dispute between us. You're going to tell them what you think the problem is. I'm going to tell them how I think there is no problem or my position on it. And then the mediator's going to make a recommendation, or the mediator is going to suggest some sort of resolution for you. The best outcome is usually the one where nobody's really happy, but everyone can say yes to it. So that's actually evidence of a good compromise.
And mediation is fast.
Mediation is usually 1 day.
Yep.
You might write some documents to provide the mediator in advance, but that's something that your lawyer, certainly things that we do at Koegle Law Group all the time. We have mediations,
weekly,
almost weekly, every week. So we're very familiar with that process and can provide those services. But yeah, it's usually in the scheme of things, inexpensive. And if it resolves your problem, it's far less expensive than litigation will be.
So one of the other options that we have for kind of an alternative for dispute resolution is arbitration. Can you talk a little bit about the arbitration process and what we have to have in place in way of a written agreement for arbitration before we reach the problem of the dispute?
Arbitration is about the closest thing to court that's not court that you can get. Arbitrators are usually or oftentimes retired judges. So you will actually have a judge or a former judge deciding your dispute, hearing evidence, hearing testimony, those sorts of things. And you pay for it. The parties pay for it. If it's business to business, you split the costs. If it's employer to employee, the employer pays. But in order to force it, let's say, you have to have a written agreement where the parties or the employer and employee agree that arbitration is going to be how they resolve their disputes. You don't necessarily have to have that agreement in order to arbitrate. You can always agree to arbitrate your dispute as opposed to mediation or filing a court proceeding. But most people don't want to do that if they don't have to. Some people, especially plaintiffs in particular, and employees in particular, think that I'll have a better chance of winning and getting a lot of money if I go in front of a judge and a jury instead of an arbitrator. And so in order to force that employee into arbitration, you have to have a pre-existing arbitration agreement. An important note here in California is that you cannot condition employment on the employee signing an arbitration agreement. So you can't say, hey, yeah, we want to hire you, but we're only going to hire you if you sign this arbitration agreement. That's illegal in California. Don't do that. But if it's voluntary and willful, that's perfectly fine. Arbitration usually is a 1-year timeline. Start to finish, you're in and out in a year.
With a decision.
With a decision. And sometimes it's even faster than that if there aren't a lot of things in dispute and not a lot of discovery to obtain. So it provides for a streamlined process that you can get a resolution much more quickly than if you filed a civil suit. Along the same lines, whether you're in arbitration or in civil court, your ability to settle with the other party is always there. You're not limited in your ability or your capacity to settle with your opponent just because you're in arbitration or just because you're in civil court. If you figure out a resolution along the way, great. And all that means is that those processes stop.
So is it fair to say that the arbitration process, since it's more expedient and arguably will result in fewer attorney's fees incurred for the businesses, a lot of businesses are opting to move into arbitration rather than litigating these claims.
Oh, absolutely. That's becoming far more common than it, even 10 years ago. And even in California, where the law is a little more strict than in other places. But, generally speaking, arbitration is going to be more of a cost advantage for everyone involved. Because even for an employee who, the employer is paying the full cost of arbitration, if they were in civil court, they'd be paying for filing fees and posting jury fees, and motions cost money every time you file. But in arbitration, that's not the case. You have some upfront costs, and you have some costs related to the actual arbitration hearing itself, but the processes along the way are less expensive.
One of the core principles at Koegle Law Group is that we are here to be the law firm as your trusted advisor. We'd rather have a long-term relationship with you than have a one-and-done type situation where we make a large chunk of money handling one arbitration. We'd rather walk alongside you, A, trying to avoid these disputes in the first place, and B, finding an expedient resolution for you that makes you understand that we're looking out for your best interests and not our own.